Welcome along to the final session of today's conference. I am Vivian White. I am the Head of Regulatory Investigations. I'm very pleased to be here this afternoon to speak to you about how we work together to manage concerns about teachers. So just a bit about me for those who don't know me. I have worked at GTC Scotland for around 11 years. I've been in the fitness to teach process all of that time. In various roles. So I used to provide procedural advice to panel members, then into solicitor role, and then into management. So I've seen a lot of cases going through our process and the types of issues and concerns that we see within it. I also have my colleague Jennifer today, who's going to be presenting some of the slides. So I'll let Jennifer introduce herself to you.
Hello everyone, so I am Jennifer McDonald. I am a Strategic Director at GTC Scotland. I have been with the organisation for over 15 years now. So I have worked in the context of our fitness to teach process since it was conceived in 2000, back in the 2000s, and put in place and enacted from 2012 on, and also had experience of the process that existed prior to our fitness to teach process. So yeah, a long time of working in and about this work as it has changed and developed over time. So really pleased to speak to everyone today, and I hope you've enjoyed the rest of the day too.
Thanks, Jennifer. So at last year's conference, I covered the high-level overview of the fitness to teach process. This year's focus is on how we can work together and what I believe is our common objective, and to strengthen our professional relationships. Our insights, as I said, come from years of working within the fitness to teach casework, seeing evidential issues and legal challenges that we've received. And Pauline mentioned earlier on this morning about our insight report, which we published last year. And that set out reflections of what we'd seen from our casework over a period of 5 years, covering 1,000 cases. So today I'm going to cover just what's on the screen there. So our shared objectives, a bit about the duty to refer and our purposes, the different purposes of the different processes. A bit about how you can help and how we'll help, some data insights, and then lastly around the rules review and the PSA report, again, that Pauline mentioned earlier on today. As a reminder, we can't talk about individual cases due to confidentiality. So if you have any questions about specific cases, please email our team inbox, which is at regulation@gtcs.org.uk. And lastly, just as a reminder, we're going to publish this video on our YouTube channel. So I think a lot of cameras are off, but just to confirm, if you don't want your face on the recording, please turn your camera off just now. So moving on to our shared objectives, we believe that we have the shared objectives of protecting learners and the public. Together, we ensure that only those who are suitable to be employed and registered as a teacher are in those positions, and where they may not be, take action if necessary. We believe it gives reassurance to the public by us working together to achieve these objectives and uphold the reputation and high standards of the teaching profession. So going on to the duty to refer, so I had this slide last year and I thought it was useful just to include again to reiterate that employers are legally required to make referrals to us when they dismiss or might have dismissed a teacher on the grounds of conduct or lack of competence, and that's immediately, so that's before if there's an appeal process, for example. So that legal requirement to refer is very wide. It includes the need to refer even where there's been a capability process followed, for example, or where there's been a settlement or a compromise agreement that's been reached. So say it's quite a wide referral obligation. Employers can refer when disciplinary action is ongoing, where the risk is so serious that we would need to take immediate action to restrict. So as I say, that those referrals can be made before a disciplinary process has concluded. And just a bit of data there, that over a 5-year period, we received 305 referrals from employers and investigated or took forward 92% of them. So there are consequences of not referring when that's required. So if a mandatory referral is not made, then obviously that would be in breach of the law. So we would ask you just to be aware of when those referrals need to be made. It can also allow issues to persist unchecked, and if the teacher leaves and goes elsewhere, they may repeat the same concerns elsewhere. It can put learners at risk by not making a referral, and obviously if the conduct or competence issues are repeated, it can damage reputation and public confidence in employers and in teachers and in us as the regulator. Just as a practical point, we have an employer referral form which walks you through the information that we need when you're making a referral to us, and that's on our website. Please provide as much information as you can within that form, because that really does help us make an informed decision about whether we need to investigate or not. And obviously we only want to be investigating where we should be taking action, or it appears that we should be taking action at that stage. Yes, so just if you can provide as much information about the concerns as possible. We understand that you might be at an early stage if this is a very serious matter, but if you can give us as much information about the concerns as possible, that would be very helpful. So just moving on to the different purposes of our respective processes. So the purposes of the employer process and fitness to teach process are different, and they perform different functions. Employers obviously decide whether an employee should be warned or removed from employment or given support, but perhaps removed from employment for breach of terms and conditions, and that's all in line with employment law. The fitness to teach process is there to determine whether someone is suitable to remain registered and be able to work as a teacher anywhere in Scotland. And that's all in line with our governing legislation and professional regulatory law. So there are different purposes and different law that covers the different processes. By law, we must only interfere through regulatory action where necessary. We should only take action where it's necessary in order to manage a risk that cannot be managed elsewhere. And in addition, by law, panels cannot know about or rely on employer findings, so they must consider the evidence themselves and make decision on whether the allegations have been found proved or not. So this all means that action could be taken at employer level, but no action or lesser action is taken at regulatory level. It should also be remembered that our panels are made up of a majority of registered teachers who have been trained to carry out the task of weighing up evidence and making decisions on the appropriate outcome in cases. So I'm going to go on now to talk a bit about how you can help us with case prospects at the early stage. Making proportionate decisions. So as I say, we want to only be investigating those cases where we should be, reassuring the public that action is being taken where necessary, and improving case timescales. So I'm going to go into quite a bit of detail about how you can help us further with this, because I believe that it will help, to give you some practical information about what we see in the process. However, before I do that, I do want to acknowledge that we've experienced very good collaboration with employers in a number of cases, and we thank everyone for their continued help with that. So my following slides, I just want to highlight where we still experience some challenges and how we can improve the process between us. So firstly, in relation to key witnesses, so these are people who have seen or they've heard events firsthand. So by law, as I say, panels cannot know about or rely on employer findings. However, as Pauline mentioned this morning, we're not an island in terms of our process. We rely on others, individuals, organisations to help us with this work. So we do rely on information and evidence that is being shared with us by employers, and our investigations are impacted by employer investigations too. We are seeing increasing challenge from representatives to statements being included where the witness refuses to, or it's not appropriate for them to attend the hearing. So this type of evidence is deemed hearsay evidence, and it has a lower evidential weight. Often these statements are being excluded prior to panel considering them due to the law around the admissibility of evidence. And this can be in the most serious cases due to the potential consequences for the teacher. So this can mean that there's not sufficient evidence left and the case would have to be closed with no action being taken. So where a witness appears at a hearing, they can be questioned by the parties and the panel to get as much clarity on the matter as possible. So this will hold greater weight than simply their statement alone. This is why we need key witnesses to be involved at our hearings. We have seen cases close without going to a hearing because we can't get a witness to attend or even engage with us. So we'd offer these pointers to strengthen case prospects at the earliest stage. If you're able to tell key witnesses that their involvement may not end with your process, that would be very helpful. And just to say that if it might be likely that we want to speak to them. We have been told by some witnesses in cases that they won't engage with us because they're told that they won't be required past the end of the employer process. So it's just as a reminder that there might be a requirement for them to be involved if the case comes to us. We carry out our work throughout the year, and so there are times we may need to get in touch during school holidays, and that's to ensure that we can progress cases as quickly as possible for the interests of everybody involved. If you can share up-to-date contact details for witnesses with us and let us know if there are contact issues that you're aware of or reticence to being involved in our process, that's very helpful. And to let us know if there are any particular vulnerabilities, since we can put special measures in place at a hearing and adjustments made when giving a statement. So we're very well aware that people can have vulnerabilities when they're engaged in the process, and we do what we can to support that. Also, just allowing people to make a decision whether they want to be involved in the process or not. We understand sometimes employers can be concerned about us contacting witnesses, perhaps if they do have a vulnerability, but it's really important that the individual, or where relevant, their parent or carer, is given the opportunity to engage and they make the decision if they want to be involved or not. Particularly relevant for learner witnesses, if you can fully engage with us in our attempt to contact them, if we can't trace them, or if there's a reluctance to be involved in our process. It's helpful if you have contact with parents, for example, explaining the importance of our process and the consequences of non-engagement. That's a helpful kind of link to us. We do understand, obviously, that there's sometimes concerns about us interviewing current or former pupils and providing contact details about them. However, this can be critical evidence in the case. We would only ever seek to interview a pupil or former pupil where we consider this absolutely necessary. So please support us in making these arrangements and talk to us about how you think we might best support the young person concerned. We do have a power to seek a court order to compel individuals to be a witness at a hearing, but we would aim to avoid using that power and would really prefer to be in contact and collaborate with the individual. Witnesses should be ready to be questioned extensively at hearings. It's only fair, obviously, that the evidence is fully tested, given the potential grave consequences for the teacher in the process. So that's obviously just part of a hearing. Please also send us unredacted documents. We do sometimes receive documents that have been fully redacted, and it means that we don't know who's involved, which witnesses are relevant, and we need to know who people are so that we can go and take our own statements. Sometimes we're having to go back to ask for the unredacted paperwork, and that's adding to our case timelines. There is a specific section on our website for witnesses that gives more information about their involvement in the Fitness to Teach process. So you can signpost them to that area of our website if they have any queries, and obviously if they have any further questions, more than happy for them to get in touch with us. So moving on to best investigative practice. The way in which an employer obtains and records evidence is critical and will be subject to detailed scrutiny within our process. We do see a wide variability in the investigative practices of employers across different types of cases. We would ask you to consider with your HR and legal teams how best to carry out investigations and whether to consider appointing an independent, experienced investigator to do so where action is likely to be taken by us. We do obviously recognise the challenge in ensuring there is the resource, knowledge and experience to carry out these processes with neutrality. However, it is a skilled and important role. Some of the issues we've seen through all of the casework we've been involved in, I've listed on the slide here. So for example, were contemporaneous statements taken, and if not, has it been recorded why? Statements should be recording the evidence fully, meaning that witness statements should be detailed, challenge inconsistencies or similarities with other witnesses' evidence, and not ask leading questions. Did the witnesses have the opportunity to discuss what they saw with others before being interviewed? And so could there be any suggestion of collusion? And linked to that, were they interviewed in groups or on their own? We've also seen some issues around how evidence has been recorded. So some statements that haven't been signed or dated. Often we've seen pupil accounts, for example, noted briefly with no date, time, location or signature and very little detail. So that makes it quite difficult when it comes to our stage. Did the witness have the opportunity to check their statement before it was signed? Were policies followed regarding the investigation itself? And importantly, in terms of best available evidence, that's the kind of evidence that we would need. So for example, sometimes we are given social media or text messages that are relevant to a case. Now, the best evidence in that would be the screenshots of the messages taken from someone's phone, showing the full screen, so names, numbers, timestamps, and then an accompanying statement from the person who took the screenshots explaining how they obtained access to the messages, by whom and when. Sometimes we've received transcripts of messages rather than screenshots, and that wouldn't be the best evidence. So it's just an example of what we would need. Where the panel has concerns about the evidence, it may be deemed inadmissible, unreliable or unsafe and may not be able to be used. And with the increasing challenge to hearsay evidence, how evidence is gathered at the very start is crucial. And it may be that things that happened earlier on can't be rectified when we've received the case. So we appreciate this is a very complex area, but hopefully these are some helpful hints and tips of things that we have seen over the years. We would ask if you could consider video recorded interviews. So this can help to resist an application we receive that hearsay evidence shouldn't be admitted. So with the increasing applications and challenge to hearsay evidence, particularly as relevant to learner witnesses, where we would want to avoid having to call them to a hearing for obvious reasons. As you can imagine, if you were the decision maker in a case, you would be better able to assess someone's evidence through a video recorded interview rather than simply just seeing the statement signed by them. Also ensuring that all key witnesses are interviewed, both in relation to those who support the allegations and those who don't, and ensure that they're fully tested. And if you can't interview a relevant witness, it should be documented within the report why. And also considering whether there are any concerns about who has brought forward the concern. So have there been any relationship difficulties or any concerns about that individual's honesty and integrity? As I'm sure you do, ensure the teacher has had a full opportunity to respond and participate in the process, and that evidence being taken into account, and any concerns that they have about the credibility and reliability of witnesses has been looked into. We have seen in some cases that CCTV can be hugely helpful to our investigations, particularly taking account of our wish to avoid interviewing young people or where they've refused to participate, along with the increased challenge to hearsay evidence. So as with recorded interviews, video recorded interviews, CCTV can really cut through a statement and show a panel exactly what's happened. So obviously as a practical point, if you're able to check cameras in schools and check retention periods so that footage is retained for enough time for concerns to be raised. We also know that layout of schools, classrooms, schools can impact in terms of who can see what's happening in a classroom, corridors, and other spaces within the building. So that's just some practical points that we've seen through cases. In terms of evidence provenance, ensuring the origin, authenticity and reliability of documentary evidence gathered in a case is key. So it must be clear what the document is, where it has come from, who created it and when. So for example, witness statements, notes, minutes and letters. Any relevant policies in place at the time of the alleged conduct should be provided and clearly marked in terms of when they were in force. And ensure that you have access to archive versions of policies, because obviously sometimes we receive allegations from something that allegedly happened a number of years ago, and sometimes it can be difficult to get policies that were in place at the time. Obviously, once informed about an investigation, if you can ensure that you retain all relevant documents, just in case we need to see them. So as you can see from all of the points that I've made in these slides, investigations at local level really are critical to our case, and sometimes it can impact on whether a case can go forward or not within our process. It's obviously quite a complex matter and a number of things that need to be considered. But I hope that's been helpful in terms of highlighting what we've seen through a number of cases. The last thing I just wanted to say on this point was about previous concerns. So it's important that local action's taken where appropriate and that we don't become involved unless that's necessary. So that's the point of professional regulation, that we only take action where that's required. However, if you're making a referral to us, please consider whether there have been any previous concerns about the teacher that would be relevant to the current issue, as this can have a significant impact on the outcome, and indeed whether we should investigate or not. There have been some occasions where we've opened a case and we've been taking statements and we've perhaps found out about other disciplinary matters that have happened that would be relevant to the current issue. So it's helpful for us to know about that at the start. Ensuring that you sort of have a clear chronology, because obviously within local authorities in particular, you could have teachers moving between the schools. And so it's just helpful to have a chronology of perhaps what's happened with that teacher during their time. And this can be highly relevant just in looking at whether there's a possibility of a pattern of conduct. So I had this slide in last year and I thought I'm going to repeat it again this year because I just think it's worth highlighting again. Just some myths within the process that we think are helpful to clarify. So in relation to where a teacher is subject to criminal proceedings, at any stage. There can be confusion about how we get to know about that. So the police don't tell us, as a matter of course, if a teacher has been charged or is under investigation for a criminal offence. We've spoken to the police about that. We used to get told, we don't anymore. Their presumption is that they will tell the employer, and they presume that the employer will tell us. But we have seen instances where the employer presumes that the police will tell us. So it's just to make you aware that we don't get told by the police directly. And so if you're aware of a teacher who's under criminal investigation, please do let us know. Similarly, Disclosure Scotland tell us if a teacher is placed under consideration for listing. They tell us where the source of referral is. So, for example, if Police Scotland have put something on to the other information, it might have come through that way. But they don't tell us what the allegation is or any other information about the concern. So we then have to go to wherever that source of referral is to ask for more information about what's alleged to have happened. As I mentioned earlier, we can't legally rely on the findings of others with very limited exceptions. So criminal cases is one of those exceptions. We can rely on convictions as proof of what has happened. But other than that, we do need to investigate ourselves and come to a finding on whether the allegations have been proved. And lastly, in relation to criminal proceedings, we may investigate an allegation even if criminal proceedings have been dropped. So it may be that somebody was investigated but no further action was taken. But we can, if it's relevant to regulatory proceedings, we can initiate our own investigation. And the reason for that is that we have a different standard of proof to criminal proceedings, and we also have different rules of evidence. So it's a lot more strict in criminal cases in terms of their standard is higher, and also the rules of what type of evidence can go into a criminal case is more strict than for our processes. So it's just to make you aware that we may pick up on a case even if the criminal proceedings have been dropped with no action. So I just want to highlight a few of the other challenges we see in addition to what I've already covered in the earlier slides. So we are seeing greater complexity in our cases. We've been seeing that for a number of years, longer hearings, more witnesses, more allegations, and that means that there are more days required for panel members. As Pauline mentioned earlier, obviously teachers are key to our process. We need 2 registered teachers on our panels, or for each panel. And so the challenge can be for us in getting availability and release for panel members, and particularly for those longer hearings. I mentioned a bit about school holidays earlier, but they can pose a particular issue for us as a regulator, in that it can be difficult to get participation in the process, either in terms of arranging a hearing or getting information from teachers or employers or witnesses during that time. Obviously, I've referred to referrals being made at the right time, so ensuring that we're receiving mandatory referrals by law when they should be. Information sharing has been a recurring theme for us over the years, and the impact is that cases are taking longer. So I mentioned in the next bullet point, we had to take Police Scotland to court a few years ago to get them to share evidence with us. So in the situation I was just talking about, where criminal proceedings are dropped and then we decide to take on an investigation, we asked for their evidence, and at that point they didn't believe they had a basis on which to share it with us. So we took action and we were successful in that. And we believe that outcome is relevant to all organisations that we are involved with. I'm pleased to say that we have seen improvement in information sharing from employers, so thank you for that. And we would just ask that continues on. And just lastly, obviously, timescales for replies can greatly impact on our overall case timescales. We know everyone's busy, but if you are able to respond as quickly as you can, it means that we can get through the investigation quicker. So I'm going to hand over to Jennifer just now, who's going to cover a couple of slides on data insights. Thanks, Jennifer.
Hello everyone again. So as highlighted throughout really the sessions today, we've been expanding our use of data as an organisation. That's been one of our strategic commitments through this strategic plan. And this slide and the next one very much reflect the work that we've been doing in that space. So for the second time, we have carried out an exercise that we have snappily called the reconciliation exercise. We're thinking of relabeling it a fitness to teach tracker. Effectively, what we've been trying to do with employers, and we've targeted the biggest employers of teachers, local authorities for now, and I'll mention a bit more about that at the end of what I say. But basically, this is the second time we've gone out to employers and asked whether all fitness to teach referrals have been made that should have been made, and effectively done a verification exercise. The latest time that we've carried this out, we have achieved an 84% response rate, which is up from 68, as the slide highlights. We are assured by the responses that we had to a large degree, in that what we have heard from local authorities is that basically what we have received is what should have been received. We are following up with a few of the local authorities that we believe we need to, in order to check they're aware of their referral obligations, and have a bit of a dialogue around and about making sure that we have received everything that we should have. In terms of what will happen in future, again, a big theme from earlier around about my GTS, we've got a big focus in digital transformation in our work. So it will probably come as no surprise that we are looking to take a more digital approach ultimately to this as well in future. So we will be looking to have our digital system support so that employers can very quickly and easily see what we've got, and effectively self-serve and do a bit of this exercise themselves. So that in that way, it will be more inclusive of all the different types of employers and contexts in which we know teachers work. So for example, the independent sector, college sector, etc. So that's been a good exercise for us to do, and important in terms of giving that assurance. Moving on to other data insights. So I have posted in the chat the report that we did last year, which looked more widely at data that we hold. So we examined 5 years of this casework and produced that Fitness to Teach Insight report, explaining and illuminating a bit more about what we've seen. We have been continuing to build and look at our data. We're hoping we will do a 10-year version of that report ultimately, as well as some other deeper dives between now and then around about some of the themes like case, referrer profile, teacher profile, etc. So watch out for them coming over the next while. But just from this last year, so as a very narrow slice of what we've seen in the last year, we received 220 fitness teach referrals, as you'll see from the slide, and then the outcomes in cases where, again, you can all read, so I'll leave you to read that. But two headline things that we would draw to your attention are that we are seeing quite a sharp increase in the number of public referrals that we're receiving. So that number has, the number as highlighted on the slide, we received the highest ever member of the public referrals last year, over 100. And we have also continued to receive mostly conduct cases. And as the slide shows, obviously a lot of cases come out of the process. So we receive quite a lot of things that ultimately we don't need to take action on. And we know that's similar to other regulatory bodies like us. And there's been a bit of a myth busting exercise around that over the years, because we found that a lot of individuals didn't understand that cases that come to us often come out of the process, and we look at things and determine that they don't need to be investigated or don't need to proceed into a hearing stage, for example. So not everything that we receive ends up right all the way at the end of the process, obviously. So that's a bit of data insights. As I say, there is a link in the chat to more data that we provide on our website, and that Fitness Teach Insight report that we've been highlighting to everyone and hoping that people will read. Thank you. Back to Vivian.
Thank you, Jennifer. So I'm just going to move on to talk a bit about the rules review that's happening at the moment and the PSA report. So we're currently reviewing our Fitness to Teach rules 2017. So these are the rules that set out the legal framework for when and how we investigate fitness to teach referrals, and then how the outcomes of cases are determined. So the current rules have been in place since 2017. So it's time for us to be reviewing them. Last year, we issued, as part of this project, we issued a call for views on the general themes surrounding the Fitness to Teach process. And thank you to everyone who contributed to that call for views. We always wanted the work for this review to be thorough. It's obviously an important area of work for us in terms of public protection and as a safeguard for the reputation of the teaching profession. So as part of our review, we asked the Professional Standards Authority, so the PSA, to perform an independent review of the performance of the Fitness to Teach conduct process. So just to explain who the PSA are, so they are the UK's oversight body for the regulation of people working in health and social care. But in addition to that role, they do offer some consultancy services to regulators in other sectors. So we know that they've done this for some regulators all over the world, and so we asked them to do that for us too. We published a summary of the feedback from our call for views and the PSA's report itself earlier on this year. What I would say is that we wanted to be constructively challenged through this review, and that's what the PSA has done. Obviously, there was no point in us telling us all the great things that we are doing, and we wanted them to highlight and recommend where we could have improvements. So the report sets out a number of recommendations and touches on known issues. And some of those issues you'll see in the Insight report that I believe Jennifer's posted in the chat. We've already begun to address some of the issues raised, but this is a wide-ranging piece of work and will take us time to work through. Some of the recommendations will require collaborative work with our partners at national level, and some also will require changes to our legislation, which is obviously a much broader piece of work nationally. So we've been working on an action plan since we received the PSA report, and taking into account all the call for views as well. And we will be publishing an action plan later in the autumn, so please do look out for that. So in terms of the report and the action plan, we are asking all our partners and stakeholders to read the PSA report and consider it in the context of the wider system in which we sit and in which we operate. One of the key points for us to consider through the report and that the PSA commented on is the reliance placed on employer processes in terms of taking local action. There was a suggestion that we shouldn't perhaps always rely on those processes, but we don't believe that sits with the PSA's principles of right touch regulation. So that's where regulatory action should only be taken where absolutely necessary, and that local action should be taken in the majority of cases. The PSA agrees with us that there needs to be an improved national understanding on the roles and responsibilities across the system when concerns are raised about someone working in education. So that links to what I picked up earlier on about, you know, for example, if somebody is subject to a criminal process, who is telling each relevant body that that has happened, who is sharing information. That's just one example of, we think, an improved national understanding of where those roles and responsibilities sit. But obviously employers are a key part of that system in terms of taking local action and investigating in the initial stages. So this is something that we've been advocating for a number of years. And as I say, the PSA agree that there needs to be that improved understanding, but I appreciate that's a very highly complex matter. We're discussing this internally within our own governance structure, but we would ask that you support us in our call for an improved national understanding about when concerns are raised and how that's handled. This links to what I outlined earlier around the expertise in carrying out investigations and best investigative practice to ensure that concerns are handled well at local level. It also requires national agreement on where an individual takes a concern, where they don't feel they can approach the employer, or where they have concerns about how the matter's been handled at local level. So this is what we see sometimes coming into our process. And so there's a question around where that sits. Our view is that we have to work together for the system to work well, and employers play a vital role in effectively handling concerns and managing risk. So that's just a bit about how what we're doing at the moment in terms of the rules review. The rules themselves, that's a longer piece of work, and they'll be going through our governance process next year. So taking all of what I've said together to conclude, how can you help? So we're obviously all working towards the same goal of children and young people receiving an excellent education and that they're safe. So we're fully committed to working together to ensure that happens. We know it's in the best interest of the process and everyone involved that cases are progressed as quickly as possible. So we hope you understand the challenges that we've been experiencing and that we can continue to work together to ensure an efficient and effective process. So just in summary of how you can help us. So if you can investigate concerns at local level using best investigative practice with experienced investigators, that would really help. And that you can communicate well with parents and carers when they raise concerns. Making referrals at the appropriate time with all unredacted documentation. If you have any queries about this in terms of what you can share, please let us know, and obviously speak to your legal teams as well. Also responding, I know everyone's extremely busy, but responding as quickly as you can to requests for information can help us progress investigations. And as a sort of practical point, considering how you can get information promptly during school closures, since we can sometimes need this to obtain a temporary restriction order, which is an urgent order that we need to restrict the teacher's registration. So we may need the information quickly in order to do that. And help us contact witnesses and encourage them to give statements, comply with deadlines, and attend hearings where that's appropriate. As mentioned before, if you have employees who are panel members, please help us by ensuring that they can be released for the work as much as possible. As I mentioned earlier, because our hearings can now be multiple days or longer than they used to be, this can mean that registered teachers need to be out for multiple days for hearings. And if whoever the request has to go to, so if it's a head teacher example, that they're aware of the commitment of you as the employer for that release to happen. Obviously supporting us in our call for the national clarity around roles and responsibilities within the wider system. And lastly, telling us if a teacher is under criminal investigation. So in terms of how we will help within the process, so we have an area of our website giving information about the Fitness to Teach process. So there's a wealth of information there. There's also a short video that we published, I think it was last year, explaining the process. So we'd encourage you to have a look at that and signpost that to others who are perhaps involved in the process. We also have a dedicated area specifically for employers on the Fitness to Teach process. Please do feed back to us if you think there's anything further that you think would be useful in that area of the website, or anything that you think needs clarification. Obviously, we're keen to improve that where we can and make it as useful for you as possible. There are also dedicated areas on our website for teachers and witnesses, which signpost areas of wellbeing support. So we know that obviously this is a very difficult process for anyone to be involved in. So we've signposted wellbeing support at the top of those pages, along with other information obviously about the process and how they will be involved. As I say, we're taking forward an action plan to take account of the views given to us in relation to the Fitness to Teach conduct process, and that's part of a project that we're initiating to take forward actions. We're working hard to ensure that everyone involved in the process is kept up to date at key points, and that includes employers. And we're continuing to work hard on reducing our case timescales. So that will be a mixture of the rules review, which we believe will provide efficiencies within the process, and other improvement actions that we can take to help with timescales. And we will obviously continue to advocate for the national understanding about roles and responsibilities. So lastly, in terms of what's next for us in the immediate term, we are looking to implement a case management system, and the relevance to that is that, as I mentioned, we're looking at case timescales, and we want to make it more efficient, and we believe this system will help with that. So that's going to be a big project for us. As I say, the review of the rules, which should obviously, which should also provide efficiencies within the process. And that all leads into case throughput and getting through cases as quickly as possible. So that's our focus for the immediate term, along with the longer pieces of work that I've mentioned. So I actually think is that bang on time at 10 to 3, which is very exciting, that's the end of our presentation. So I hope that you got some useful information from that. As I said before, if there are any questions about specific cases, please do let us know and email our inbox. It's really just for me now to say thank you very much. This is the last presentation of the day. Thank you to those who have stayed to listen to this and throughout the day. A feedback form is going to be sent out in the next couple of days, and it'd be very helpful for us if you could complete that and let us know what you thought of the sessions today, and also any suggestions for future conferences that we can pick up. So unless there are any other comments that I think would need picked up, I know that they've been answered as I've been speaking. So yes, thank you very much to everyone, and enjoy the remainder of your day.